23P 947. As the party set up, I want to remind everyone that this case is impounded, so we are not going to use any names. We can refer to the children as child 1 and child 2, or older child, younger child, but no names. So appellees, how are you splitting your time?
10 and 5-year-old.
10 and 5, and then appellant 7.5, 7.5. Okay. And who's going to go first for the appellant? Let me just make sure Ms. Fisher's okay with the time break. So 7.5, 7.5, and then 10, 5. Good. All right.
Good morning.
Good morning.
My name is Lynn Alderman Boyer, and I represent the appellant mother. And so today, Your Honor, as we just discussed, we'll be splitting with the appellant child, 7.5 minutes each. And I'm going to focus my argument on the sufficiency of the evidence and break it down into 3 issues, if possible, from my brief. So basically, mother argues that the evidence taken together does not support the trial court's finding of mother's unfitness and termination of parental rights by clear and convincing evidence. And I just want to start off by reading just a short little clip on sufficiency of evidence from Adoption of Rona, which states, current parental unfitness must be proved by clear and convincing evidence. This standard of proof falls between the burden of proof by a fair preponderance of the evidence and the burden of proof of beyond a reasonable doubt required in a criminal case. However, the required evidence must be sufficient to convey to a high degree of probability that the proposition is true. And the 3 issues that I want to focus on is the first one is the trial court's, which we argue is reversible error, reliance on unsupported reverse 51As and 51Bs. The second one is going to be reversible error when finding that mother has not ended her relationship with the father in this case. And I just for clarity, when I refer to the father, that's MW, which is the stepfather for A and the father for P. And then the last is which we argue is reversible error, is the finding that mother did not benefit from services and her mental health was unstable. And those would be the services that she largely, roughly at least a year before the trial ended, that she participated in. So the 51As and the 51Bs in this case, as my brief has set out, and also just wanted to remind the court that I also joined the appellant child's brief as well for both the response brief and the principal brief. There are substantial amount of 51As and 2 51Bs. So there were 2 fair hearings, as I stipulated in my brief, and in those 2 fair hearings, they were both reversed. In the first one in 2018, there were 4 51As and 1 51B that was reversed. And so those were all from like 2017. Fair hearing happened in 2018. In 2019, August of 2019, there was another fair hearing. Both of these fair hearings were requested by mother and father, so the reversals were for both of them. And those were for the December 2018 51B, in the 2 51As and resulting 51B for the removal of child A and child S. So there's 3 children, only 2 are involved here in this appeal. The first, child S, mother's rights were not terminated for that child. She was returned to her father, though. So this is pretty significant because the judge does refer to these 51As and 51Bs in the findings or in the conclusions, actually. I found a lot of the findings of the judge really just recited a lot of the facts of the case, and a lot of the real meat was in the conclusion in these findings, in the multiple conclusions. And these 51As and 51Bs are relied upon pretty heavily throughout. The first fair hearing is in the evidence that was submitted by mom. It's pretty lengthy. There's 32 findings and 11 paragraphs of analysis. And at the end of that, all of those 51As and Bs were reversed. And the second one is not in evidence in terms of physically being in there. However, the department, ongoing social worker for mom, refers to this fair hearing, reversing the December 2018 51B and 51As that led to the removal of A and S from mom at that time. And it's mentioned twice in the record. And so I would just like to argue there that this is reversible error. It's not harmless error to mom. It was used heavily. And the department takes 2 cases, or 4 cases really. Rona and Lorna are 2 of the ones really relied upon. And the adoption of Rona says an unsupported 51A report may be used at trial against a parent. The evidence must be sufficient to convey to a high degree of probability that the proposition is true. I just want to say, I feel like this is it is distinguishable, because those cases, the 51A that they're talking about, those were not reversed. They were not reversed through a fair hearing. And the fair hearings, and I'm not sure if you would want me to read this out, but in my response brief, I did go through a lot of the 110 CMR rules through the department on the fair hearing. Even though the rules of evidence really don't apply, it's pretty strict, and they give they defer to the department, and they give a lot of deference to the department. They are final decisions once it's actually sent to the main office, central office, and if it goes there for 21 days and it comes back, it's a final decision. I feel like it's very distinguishable here. It's not just about objecting to a 51A of it coming in to just set the stage. This is about something completely reversed by the department itself. And in those findings...
Let me just ask you this. Was there any evidence that the mom abused her children?
So, Your Honor, aside from these 51As, I think that one of the things that I would argue that is important is that there were nobody came into trial to testify about, if the 51As, if there's some corroborating evidence out there, clearly that's going to take precedence over 51A. If say, the 51A reporter who's unidentified comes in and testifies to what they saw. There was nothing of that. The social worker did testify to the same information that was in the 51A, but just to say that he had read it, and this is what it states. So there is no evidence of that, and I would say that in conclusions 18 and 19, the judge actually does carefully state in the way that she's phrasing things that they're not really, sure if this actually happened. And there is a little discussion about mom giving testimony about disciplining. And the judge is careful to say, too, that doesn't really know to the extent that a disciplined mom says a small tap. And, we cite to Commonwealth versus Cobble, and also that mom is saying small tap, not in anger, not hitting hard or anything like that. So the judge is careful on how she actually discusses it. She doesn't really say, we know for certain mom did something wrong.
Check, because you are out of time. I want to see
yes.
if the panel has any further questions.
Oh, that goes quick.
I'm going to have to leave it on your brief.
Okay, thank you, Your Honor.
Attorney Berry?
Thank you. Good morning, Your Honors. My name is Jessica Berry, and I'm arguing on behalf of the appellant child, who's the older child on the appeal. And he is seeking that the decision be vacated. All 4 of the decisions, really. The unfitness, termination, the lack of a parent-child visitation order, and the lack of a sibling visitation order. Before I get into the meat of my argument, I do just want to let the panel know that I did discover a mistake in my brief on page 28, note 4. It says that the child at trial supported termination, and that is not, in fact, the case, and I very much apologize for that. You can see on transcript page 680 to 81 that at trial, that my client did not support termination. He supported that he be found in need of care and protection, but he did not support termination, and he asked for significant sibling visitation for many of the reasons that we argue in our briefs. I want to just talk counsel.
Thank you for bringing that to our attention, and that was the right way to do it, so thank you.
Counsel for Mother talked some about the reverse 51As. I just want to spend 1 minute more on that because I really want to really get to the meat of why it was so harmful. What happened was the trial judge did not recognize that this December 2018 51A, which was the reason that my client was removed from his mother, that support decision, DCF initially made a support decision, and then it was reversed at a fair hearing. So Mother did not agree with that decision. She requested a fair hearing, a check on that decision saying this didn't happen, and so you review it. You get an administrative hearing in front of DCF employees and internal office, and at that administrative hearing, DCF presents evidence, Mother is entitled to present evidence, and either can present evidence since the time of the investigation, and as a result of that review, DCF decided that, in fact, they did not have reasonable cause to believe that abuse or neglect had occurred, that my client's mother had not abused or neglected the children. But by this point, the children had already been in care for 10 months. And that whole 10 months, Mother had been doing everything that was asked of her on her action plan, except for that she was not able to get Mr. W, the father of the younger child, to participate with DCF. So Mother gets this decision. She thinks, great, finally, I have this decision that says I did not do the thing that I've been saying I did not do, but DCF does not change how they treat Mother, and they continue to expect her to acknowledge this abuse and neglect that DCF has now said they don't have reasonable cause to believe has occurred. And the reason that this is harmful is that the conclusions are packed full of the lower court judge, saying that Mother has these parental deficits because she did not cooperate at times with DCF, because she did not acknowledge this abuse, and because she did not, and that she wasn't working on these issues. But the fact of the matter is, of course, Mother is frustrated. She has been saying along that she did not do this thing. She went through the process of getting this reversal, and was doing at the same time was doing everything that DCF asked of her, and still they're asking her to acknowledge this thing that DCF itself has recognized did not occur. So that is the harm.
It's a very interesting point that you made, and I'm just trying to understand exactly. So in this instance, because of the length of delay in getting the fair hearing and finally getting your opportunity, and she's engaged in counseling and treatment, what if she showed up 3 or 4 days a week, not for this particular mom, but in my hypothetical, under the influence, and combative, and this and that? Any evidence of during that time when otherwise she wouldn't be doing this plan because 51A wasn't supported? What do you make of it?
During that time, that 10 months? Yes, so of course, and that's what I want to get to next, that if there was something that had happened during that time, then number one, DCF could have introduced that evidence at the fair hearing, but number two, yes, then she would have to acknowledge that behavior. And that gets me to the point about Mr. W, and that's a wholly separate issue, right? It is intertwined, but there's the issue of her being in a domestic violence relationship, which is separate from that 51A that said that she herself had abused or neglected her children. So now we have the situation where she acknowledges that she was involved in a domestic violence relationship with Mr. W. It took her a while. It took her a while to acknowledge that, but she does it. So there's sort of like two pieces to this. There's that period at the beginning, December 2018, until about April 2020, with some little break in between, where she's doing everything, and then she just gives up. It's COVID. She's done everything. She got this reversed. She's given, she gives up for a year. I mean, we don't know, she was involved in some therapy, but she wasn't cooperating with DCF. But then in December 2021, so she gives up for about a year and a half. But then in December 2021, the record is very clear that at that point, Mr. W. was incarcerated in Ohio. And maybe that was the impetus for her, having that ability to sort of break free from the cycle, but it's very clear that at that point she begins engaging in services. She re-engages the department. The service providers are saying that she's making tremendous progress and that she's in parenting groups. She's in intensive individual therapy. She's doing the things she's supposed to be doing on her action plan. And then we have trial, and all the way through to trial in September 2022. And so that's, I think, the second piece, this acknowledgement of DV, and that did not happen initially, but it did happen, and it happened for a very prolonged time. You will hear from the appellees that she had at various points in the earlier part of the case made statements, yes, he's not good, this and that, but it wasn't really until that period. I mean, in the record, it's very clear from March of 2022 at least, and even before that she is very consistent that he is not.
The client will be 10 this month, I believe.
Yes, 10 this month.
So is your position one of substituted judgment?
No, Your Honor.
Okay.
I do also just want to say that, in terms of if this court does determine that mom was currently unfit, you can still look at all the progress that under Carlos, you can still look at all the progress that she was making to determine that you should not terminate parental rights. And, in the record, my client lost his father when he was 3 years old, and he still grieves that. And he just shouldn't have to lose another parent, especially one that was making the progress and working hard in order to get her child back.
Thank you very much.
Thank you.
We will now hear from the department.
Good morning, Your Honors. May it please the Court, Matthew Price on behalf of the Department for Children and Families. The Department is asking this Court to affirm the lower court's decision that terminated mother's parental rights. The Department has been involved with this family since 2014. Mother, as you've heard, had 3 children, none of whom are in her custody anymore for the same reasons. From 2014, when the Department was involved, through 2019, when the youngest child was removed. These are bookends, if you will. In 2014, there were concerns raised around how the newborn child A was not properly attended to and not being fed. Fast forward to 2019, there were concerns raised that newborn P, the 3rd child, was not properly attended to and crying all night. There was no discernible change in mother's ability or attitude towards parenting.
Let me ask you the same question. Was there evidence here that we can consider that the mom abused her children?
Yes.
All right, and what is that evidence?
The evidence that mother abused the children was the child's statements, that mother slapped him when she was frustrated. The court considered that. The court also considered mother's own testimony regarding her method of discipline, which was which it considered physical punishment, and that mother's description of tapping was minimizing what actually took place.
Well, see, this is a difficulty I have, because when I read her testimony, she didn't acknowledge any abuse. She said she would tap them on the hands, that sort of thing. But the judge didn't, when I read her findings, I didn't see the judge come down on one side or the other. She just kind of summarized what the conflicting evidence was and sort of left it there and said, well, I don't credit what, the mom has said about, for example, when the mom was testifying about whether or not she had been abused and whether she had been struck by her husband, she initially said no, and then, well, he struck me once. Well, he struck me more than once. And the judge summarized that and said, well, I don't credit her testimony. So what do we do with that?
Well, the judge didn't credit her testimony with only being hit once, or the number of times that she was saying that she was hit, which was one time. I mean, that was the judge's, role in terms of hearing her testimony and what she had to say and evaluating that. I think that the findings and the conclusions show that she considered, she balanced it out, and her decision included that there was physical abuse in the home, there was domestic violence, there was physical abuse as a form of discipline to the child when she was frustrated, which was an example of her not being in control of her emotions, and that was attributed to her mental health. Within the period of time that the children were with her, this was not an example of a one-off incident. During those 5 years, there were approximately 16 51A reports that were filed raising concerns with how the children were being cared for. And during that time, in 2017, is when Mother married Mr. W. She married him in July. She said that she was unsafe with him, and I think the implication is the children were doubly unsafe with him. In September of 2017, there were a series of 51As that were filed concerning how the children were being treated. And in October, the older child, Child A, under a probate court temporary guardianship, was sent to live with his aunt. Approximately a year later, in 2018, he was returned to Mother's care. She was still with her husband. And 4 months later, the children were removed in an emergency removal as a result of pretty serious physical abuse by father. During this time, where they were in Mother's care, she had, aside from her own forms of discipline, she had a responsibility of care to the children, and she was not protecting them from him, even though that her own statements were that it was a bad relationship, he was unsafe. She continued to stay with him throughout until 2021, excuse me, at which time she didn't separate from him, and I don't think that the court really saw her as separating from him. He went to prison, and it was a forced separation, and that is what initiated that break. And the court was not convinced by the evidence that when he is released from prison, that Mother wouldn't take him back, and had to consider putting these children back in that kind of an environment. So all of that was before the court that it considered when it was balancing out the risk that these children would be placed in.
What's your position on Child 2's claim of error on sibling visitation? The younger child said it was error not to enter a sibling visitation schedule. What's your position?
I don't think that it was error, Your Honor. I think that the children are both represented and can, if they want to change, they can file motions with the juvenile court that still...
Children won't be represented forever, will they?
No, but they are represented now, so they could certainly file a motion for more visitation if they want. They haven't been adopted yet. So that would, so I don't think it is error on that part. I think the judge considered what was going on as far as regular visits were happening, and the department was facilitating that, and that it served the children's interest, and that could be allowed to continue. And at the same time, there was
So you would oppose a remand for a sibling visitation order?
I would oppose a remand, but if the court decided to do it, I would just remind the court that a remand for visitation doesn't necessarily have to affect or shouldn't affect the decree of termination.
Understood.
The other aspect of mother's unfitness that I think was prominent and stood out was her ongoing mental health and its instability. She had a long history of being involved in groups and therapy and taking medication, none of which worked. She did not make progress from that. There was evidence that she was involved in, she had done a domestic violence group, she had done parenting classes, she had been in therapy, which was admirable, but ultimately her ability to manage her emotions and control herself, which was the bottom line, was not effective because she could not manage in these group settings with adults facilitated by an experienced person. She needed a higher level of care in one-on-one settings to be successful. And where you're talking about her taking over custody of 2 small children and using discipline of slapping her older child's face when she's frustrated, that was considered by the judge, and rightly so, I think, that would not be a safe scenario to put the children back into. I see that I'm short on time, so I will just wrap it up with that unless there's further questions and rest on my brief.
I don't see any additional questions. Thank you. Attorney Appleyard?
Good morning, Your Honors. May it please the Court. Jennifer Appleyard, representing the youngest child in this matter. Here today to
start with your question about sibling visitation, because I know you say it's a claim of error and it needs to go back, but doesn't the department have the discretion as to how to handle it, and they don't necessarily need a specific order? And if the visits aren't happening, you could bring an action below?
I would suggest to the Court that in this particular case, the trial judge made findings that there was a significant bond between the youngest and the oldest. And as
I read it as having, like we would do with an adoptive parent, leaving it to the adoptive parent. She's leaving it to the department at this point.
My client expressed a direct wish to have regular visitation set up. So it would be my position that because regular visitation was not clearly designated, that I would ask the Court to issue such a specific order. I would ask in this case for the Court to affirm the finding of parental unfitness as well as to affirm the termination of parental rights. I think it's important in looking at the youngest child's case. It began in 2019, and said child was removed in 2019 based on different concerns, but based on allegations of neglect. I think it's important for the Court to look at the 36 months that this case occurred, and it looked at the amount of time mother was able to visit with the youngest child and the quality of those visits while they started off, and then certainly the pandemic happened following the end of 2020 and the beginning of 2021. No visits occurred when looking at the case in its totality, there were approximately 12 to 13 visits which occurred with mother, and of those visits, there was some significant challenges the youngest child had with attachment, and mother had difficulty in terms of redirection as well as using appropriate language to soothe and calm some of the child's anxieties and some of the child's at times hesitation to even continue on with the visit. One time the child had to leave early, and another time she was not able to soothe him in an appropriate manner. In looking at some of the concerns surrounding the domestic violence or the controlling behavior on behalf of the youngest child's father, I would also have the court look as recently as her testimony at trial, in which mother did provide inconsistent testimony regarding allegations that had occurred, which Justice Hodgkins, I believe you referenced in finding 59 regarding the number of times that an incident, but that abuse may have taken place. I would also think it's important to show in finding 168 and in the record appendix 344 how in 2022 mother, in speaking with the social worker, stated that she might let him back in if his mental health was in check. There were large periods of time that mother remained on the waiting list regarding seeking treatment for her mental health, and there were times in which she was not consistent in therapy during the pendency of the youngest child's case that was going on. I think that the court could take note of when mother stopped taking her medication earlier in 2016 and stopped therapy. It was at that time mother ran into challenges with parenting the two older children. While mother certainly began to engage in therapy when looking at the totality of the case, it was for a very small amount of time in the youngest child's life. For those reasons and the reasons in my brief, I would ask you to affirm, as well as to issue visitation between the siblings.
Thank you very much. The case is under advisement. That concludes this morning's sitting. I'd like to thank the court officers, our timekeeper, our law clerks. Court will stand in recess. Thank you, everyone.
Court all rise, please.